There is a single document, signed into law on May 20th, 1862, that transferred more land in a single legislative stroke than the combined territory of France, Germany, Spain, and the United Kingdom, 500 million acres, not conquered in war, not purchased through treaty, transferred, quietly, legally, and with a precision that suggests the outcome had been engineered long before the ink dried. The Homestead Act of 1862 is taught in every American schoolroom as the crowning democratic gesture of a young republic. Free land for free people, the frontier open to the common man. That is the version they tell. What the records show is something considerably more specific and considerably more disturbing. The land did not go to the common man, not most of it, and the evidence suggests it was never intended to. The standard account runs as follows. In the middle of a civil war, Abraham Lincoln signed legislation granting 160 acres of federal land to any citizen willing to settle and improve it for 5 years. It was, in the telling of every major American history textbook, the fulfillment of Jeffersonian democracy, the yeoman-farmer ideal made real across the Great Plains. Millions of ordinary Americans, the story goes, took up the offer and built the nation's agricultural backbone from raw soil and honest labor. But that explanation has a problem. When you follow the actual land transfer records, not the promotional literature, not the congressional speeches, but the deeds filed in county courthouses from Ohio to Oregon, a different map emerges. The railroads received more land under the same period's legislative framework than homesteaders ever did. The financial institutions that financed those railroads held liens on land that had not yet been settled. And the federal bureaucracy created to administer the act, the General Land Office, was simultaneously processing homestead claims and quietly reclassifying millions of acres as mineral-rich, timber-valuable, or strategically located, removing them from homestead eligibility before a single family could file. What has been overlooked is not a footnote. It is the entire operating logic of the act itself. Begin with the numbers, because the numbers refuse to cooperate with the official story. Between 1862 and 1900, approximately 80 million acres were claimed and patented under the Homestead Act, meaning settlers completed the 5-year residency requirement and received full title. That figure is frequently cited as proof of the Act's democratic success. What is cited far less frequently is what happened to the other 420 million acres of federal land transferred, sold, or granted during the same period. The Pacific Railroad Acts of 1862 and 1864 alone granted approximately 170 million acres of federal land directly to railroad corporations, more than double the total land ever claimed by individual homesteaders across the entire 123-year life of the homesteading. The Union Pacific and Central Pacific did not earn that land through 5 years of honest labor. They received it as capitalization, as financial infrastructure, before a single mile of track had been laid. Then came the mechanism that made the whole system function. On July 1, 1862, the same year the Homestead Act was signed, Congress passed the Pacific Railroad Act. It did not merely grant land to the railroads. It created a structure in which the federal government issued bonds on behalf of the railroad companies, meaning the United States Treasury became the financial guarantor of private corporate expansion. The railroads received land grants in a checkerboard pattern, alternating sections of 1 square mile each along the rail corridor, with the federal government retaining the intervening sections. The logic presented to the public was that the retained sections would increase in value as the railroad developed the region, allowing the government to recoup its investment. The logic that actually operated was different. The checkerboard pattern meant that no homesteader could settle a coherent, contiguous farming unit without either purchasing railroad-owned sections at inflated prices or leaving gaps in their claim that made agricultural viability nearly impossible. A family who filed a homestead claim found themselves surrounded, on alternating sections, by land they did not own and could not afford, land held by a railroad corporation that had received it for free from the same government that had promised free land to that same family. In 1887, journalist and economist Henry George published a detailed analysis of California land ownership patterns that documented what he called the systematic monopolization of the public domain. George's research, drawn from county assessor records and general land office filings, showed that in California alone, approximately 17 million acres, land nominally available for homesteading, had been acquired by fewer than 200 individual landholders and corporate entities. Among them, railroad corporations, land speculation syndicates, and a network of legal agents who filed fraudulent homestead claims on behalf of timber and mining companies. The process had a name inside the industry. It was called dummy entrymen, paid proxies who filed homestead claims, completed the nominal residency requirement through a legal fiction, and then transferred the deed to the corporate principal. The General Land Office knew. Congressional investigations confirmed it. Nothing changed. The land stayed in corporate hands. The investigations produced reports. The reports produced recommendations. The recommendations produced nothing. No official explanation has ever addressed why the enforcement apparatus consistently failed to disturb the outcomes the fraud had produced. What happened next is documented but rarely mentioned, together with the act it was designed to exploit. On March 3, 1891, Congress passed the Forest Reserve Act, granting the President authority to withdraw federal lands from all forms of entry, including homesteading, and designate them as forest reserves. It was passed during a lame duck congressional session attached as a rider to a general land revision bill. It received almost no floor debate. Within 11 years, Presidents Harrison, Cleveland, McKinley, and Roosevelt had withdrawn approximately 150 million acres from the public domain. Withdrawn from homesteading eligibility, withdrawn from settlement, returned, in effect, to federal custodianship. The man most associated with this withdrawal program was Gifford Pinchot, first Chief of the United States Forest Service, trained in European forestry management, and a personal friend of J.P.P. Morgan's inner circle of financial strategists. One instance of land removal is an administrative decision. 2 instances become a policy tendency. 3 instances, the Railroad Acts, the fraudulent homestead claim networks, and the Forest Reserve withdrawals, begin to describe something with a shape. The shape is not chaotic. The same outcome reproduces itself across different actors, different decades, different stated rationales. The valuable land, mineral-rich, timber-dense, water-adjacent, strategically located along the transcontinental corridors, reliably ends up outside the reach of the ordinary settler, every single time. There was a human cost to the land transfer records cannot fully quantify. Between 1865 and 1900, approximately 500,000 families filed homestead claims in the Great Plains states, Kansas, Nebraska, Dakota Territory, Colorado. Of those, historical estimates suggest that fewer than 40% ever completed the 5-year residency requirement and received a final patent. The rest failed. They failed for identifiable reasons: drought, grasshopper plagues, the inability to afford the machinery necessary to break virgin prairie sod, and, most commonly, debt. Debt to the very railroads whose land grant monopolies had made contiguous farming units impossible to assemble. Debt to the banks that had financed those railroads and now extended agricultural credit at rates calibrated to ensure a reliable cycle of default and land recapture. In the winter of 1873 and 1874, a grasshopper plague devastated crops across Kansas, Nebraska, and Minnesota. Approximately 200,000 settlers in those states faced starvation. Federal response was minimal, in part because the same congressional session that was declining emergency agricultural relief was simultaneously processing additional railroad land grants through the same Department of the Interior. The names of those failed homesteaders are in the county courthouse records of every Plains state. They filed, they built, they broke. Their land went to satisfy debts owed to institutions that had received their own land for free from the same government under the same legislative session. They did not fail because the frontier was hard. They failed because the system they were operating inside had been structured from its legislative foundation to make their success geometrically unlikely while making institutional consolidation geometrically certain. The pattern has a structure. It operates in 3 phases, and it reproduces itself with remarkable fidelity across American history wherever large-scale public land disposition has occurred. Phase 1. A public legitimization narrative. The land is to be given to the people. The language of democratic distribution is deployed with maximum visibility. Congressional speeches, presidential signatures, newspaper coverage. The narrative serves 2 functions simultaneously. It creates political support for the legislation, and it establishes a historical record that will later make the actual outcome appear to be an unintended failure rather than an intended result. Phase 2, a structural impediment embedded within the legislation. The impediment is not visible in the headline of the bill. It lives in the coexisting legislation, the land classification rules, the administrative discretion of the implementing bureaucracy. In 1862, the impediment was the Checkerboard Railroad grant. In the 1870s, the impediment was the classification of the most valuable land as mineral or timber reserve before homestead filings could be processed. In the 1880s, the impediment was a general land office so underfunded and understaffed, deliberately the appropriations records suggest, that fraudulent corporate filings moved through the system faster than legitimate homestead claims. Phase 3, the retrospective explanation. When the democratic promise fails to materialize, the failure is attributed to nature, character, or historical circumstance. The homesteaders failed because the land was hard, because the climate was unpredictable, because they lacked capital. The structural impediment is never named as an impediment. It is absorbed into the general narrative of historical complexity. This three-phase pattern does not appear only in 1862. It appears in the Dawes Allotment Act of 1887, which promised to distribute reservation land to individual Native American families, while simultaneously creating a surplus land mechanism that transferred 90 million acres of reservation territory to white settlers and corporate interests within 25 years. The public narrative was assimilation and individual land ownership. The structural impediment was the definition of surplus. The retrospective explanation was cultural unreadiness. It appears again in the Reclamation Act of 1902, which promised to bring water to small western farms through federal irrigation projects, while simultaneously restricting water rights in ways that, within a generation, had consolidated most irrigated acreage into large corporate agricultural operations. The public narrative was the family farm. The structural impediment was the water rights framework. The retrospective explanation was economic efficiency. 3 instances. The same architecture, different names on the legislation, but the outcome is identical each time. What the congressional record actually shows, I spent a considerable period working through the congressional record for the 37th Congress, the session that produced both the Homestead Act and the Pacific Railroad Acts in 1862. What I expected to find was evidence of competing factions, agrarian Democrats pushing for homesteader rights, industrial interests pushing for railroad grants, with the legislation representing a compromise. I did not find that. What the record shows is more specific. The primary architects of the railroad land grant provisions, Congressman Thaddeus Stevens of Pennsylvania, Senator James Harlan of Iowa, and the central lobbying network organized around Thomas Durant and the Union Pacific Railroad, were not in opposition to the homestead provisions. They supported them. They voted for them. In several cases, they championed them publicly. The Homestead Act and the Railroad Acts were not competing visions of Western development. They were, in the documentary record, complementary instruments advanced by overlapping personnel with a shared understanding of how the Western landmass would ultimately be organized. The homestead provision was not the agrarian faction's victory over the railroad faction. The evidence suggests it was the railroad faction's public relations architecture for the same set of transactions. The Homestead Act was formally repealed in 1976 with the passage of the Federal Land Policy and Management Act. The final homestead claim in the contiguous 48 states was filed in 1974. By that point, the federal government held approximately 650 million acres of land in the western United States. The land consolidation that began in 1862 had not reversed. It was completed. Those 650 million acres are currently administered by a network of federal agencies: the Bureau of Land Management, the Forest Service, the National Park Service, the Bureau of Reclamation, whose founding charters, administrative structures, and in several cases founding personnel, trace directly back to the same institutional lineage that administered the original land transfers. The land has not moved. The administrative philosophy governing it has not fundamentally changed. There are mineral extraction leases on federal land whose terms were last publicly debated in the 1920s. There are water rights frameworks governing federal land adjacent to the largest aquifer systems in North America, whose legal architecture was drafted by the same generation of attorneys who processed the railroad land grants. There are land management decisions being made today under administrative discretion that trace in an unbroken legal line back to the Forest Reserve Act of 1891. The consolidation that began in 1862 was never reversed. There is a principle at work in the history of the 1862 Land Act that extends well beyond the specific question of who owns the American West. Every major system of public resource distribution in the modern era has been accompanied by a public legitimization narrative describing democratic access and individual benefit. And in each case, the structural mechanisms embedded within the administrative framework of that distribution have reliably redirected the most valuable portions of the resource toward institutional beneficiaries operating at a scale and with a legal sophistication that individual participants could not match. I am not claiming that a hidden council designed the Homestead Act as a deception. I am describing something more specific. The people who drafted the coexisting railroad land grant provisions were sophisticated financial and legal professionals who understood land valuation, water rights, mineral extraction economics, and the mechanics of debt-financed agricultural development. They knew in 1862 what the checkerboard pattern would do to homestead assembly. They knew what dummy entrymen could accomplish at scale. They knew that an underfunded general land office would process corporate filings faster than individual claims. That knowledge was present at the drafting table. Its consequences were foreseeable. The fact that those consequences materialized with such precision and such consistency across multiple decades does not require a conspiracy to explain. It requires only the recognition that the people who design systems tend to design them to produce outcomes they prefer. The settlers of 1862 did not know what the checkerboard pattern meant for the coherence of their claims. The technical knowledge required to understand it was professional knowledge, the kind held by surveyors, railroad attorneys, and land agents. The ordinary farmer filing a homestead claim in 1863 was making a decision inside a system whose actual operating logic had never been explained to him. He was operating on the public legitimization narrative because that was the only version he had access to. That asymmetry of information between the people who design systems and the people who live inside them is not a feature of 1862. It is the operating condition of every large-scale public institution that has existed since. Every time a public institution announces the democratization of a resource, whether land, telecommunications spectrum, data infrastructure, educational access, or public health, the same analytical question applies: who designed the administrative framework? What did they know about how it would function in practice, and who ends up holding the most valuable portions of the resource once the public legitimization narrative has done its work? The answer to that question, across the historical record, has been remarkably consistent. The question the history of 1862 raises about the present is not whether the system was designed to serve interests other than the ones it publicly named. The documentary record answers that question. The question is whether the administrative framework built on top of those original transfers, refined across 160 years, staffed by successive generations of professionals who may have had no knowledge of the original design logic, still produces the same categories of outcome. Whether the three-phase pattern has simply become an institutional habit. Whether the public legitimization narrative and the structural impediment and the retrospective explanation of failure have become so practiced, so routine, so thoroughly normalized, that they no longer require anyone to intend them. The question has been there since May 20, 1862. Nobody has answered it yet.